Again, I'd like to thank Candace and everybody who's coming out. This is the first chance we've all got together. We've probably all felt like we've been fighting a fight on our own, and it's good to get together and be able to share stories. I'm not sure if you've noticed the progression here, but we're going along in expertise or weariness, one or the other. Our fight has been for 8 years now, and it started off with a very poorly advertised single meeting out in a rural area for the terms of reference, and about 120 people showed up, and they were trying to squeak that terms of reference in with very little community input. But the cat got out of the bag, and the community organized its own meeting a couple of weeks later, and there was 1,200 people in a small school gym. In fact, they were out the door. We don't know how far out the door they went. So that's just one of the games the proponents play. They try to push things through as quietly as they can. Our proposal is in West Carleton, is on the west side of Ottawa. There is an existing landfill on the site, which is now closed as of 2011. And the proponent is proposing a brand new landfill to the north of it. The proponent is Waste Management of Canada, and I guess I'll give a little history about the old landfill and the site, because it's very pertinent to the proposal. The old landfill, the two major concerns of the old site were odor and groundwater, and a third one is proximity to the urban boundary of Ottawa. The odor issue was one of major problems back in from about 2004 on until when they closed the site, and the proponent was not recording any complaints. The ministry was not recording complaints, so the community took upon itself to set up a website where complaints could be put on the web page and automatically sent to the MOE and the ministry, the MOE and the proponent. The worst year was 2007, when we got over 5,000 complaints on odor, and in total there's over 7,500 complaints were put in. That made the ministry kind of take notice, and they said, "Oh, I guess you have an odor problem." And actually the ministry started to do an investigation. They were actually going to charge Waste Management for breach of environmental law and committing odor offenses on the community. They actually hired an investigator who was investigating, and we felt that we were going to be vindicated, and this troublemaker was going to be taken to court and actually had to stand up and admit to his the problems he was causing in the community. Unfortunately, MOE backed down. They looked at the report from the inspector, and they basically said, "I don't think we can win in court, so we'll slap Waste Management on the wrist, we'll tell them do better," and that's all that happened. Oh, in the meantime, in 2007, they went ahead and, even though with all this odor going on, they went ahead and approved a certificate of approval for air emissions, because Waste Management was planning to do some work on the site. And part of that approval was modeling, which showed that there would be no odor emissions from the site, even though there was 5,000 people complaining about odors. So we appealed to the Environmental Review Tribunal on that case, and we won leave to appeal. The Environmental Review Tribunal agreed with us that the modeling that was being used by the proponent to prove that there was no odor was totally flawed, just by reality that there were odors. And based on that, we went into mediation with the proponent, and we got a fair amount of concessions from them, and one of the concessions was that they would close the site by 2011, even though they wanted to keep going until 2014. So the reason it's closed now is because of the community's efforts. The other issue that is of concern is the groundwater issue. The site is on an old sand and gravel. It's on an esker. It's an old sand and gravel pit area. And the sand and gravel sits on top of fractured limestone, the very same fractured limestone that is down in Napanee. The site, the existing site, is leaking off-site. The proponent has had to purchase nearly 50 hectares of off-site property because of contamination. They are being monitored by the MOE. And again, the problem with MOE seems to be they don't want to use the teeth they have. The community was concerned that the actual boundary of the leachate plume isn't well defined. How far it goes isn't well defined, and we asked MOE to have further wells, monitoring wells drilled so that we would know exactly how far it went. MOE asked the proponent to provide some more wells farther out, and the proponent came back and said, well, no, we can't do that because, and they had a bunch of reasons why they couldn't do it, and MOE basically accepted the proponent's rationale. 2 years after that, the MOE finally started to realize that there wasn't a good handle on how far the leachate was going, and they finally did get the proponent to drill new wells. But to me, the MOE does not use the power it has as a regulator, whether it doesn't want to get confrontational with large proponents, I'm not sure, but they didn't want to, they didn't use the regulatory abilities to enforce, to actually understand where the groundwater issues are going. We, because of the community uprising in 2006, the proponent pulled back his terms of reference, went back to the drawing boards and made a few modifications and came back again with a revised terms of reference. And the community spent a lot of time and effort putting together a huge document that had a lot of comments about the terms of reference that the proponent wasn't addressing. And a lot of them have been talked about here right now. One of them, it was a scope DEA, so there was no rationale or defined need. And once again, they pulled back their terms of reference and they sat on it for a while until they came back in 2010. And this is one issue I have with it. As a community, there's only so much time that the community can contribute to fighting it. And yet the proponent has all the flexibility in the world to keep going back and pulling back until the timing is right, or until they've worn down the community to the point that there's no fight left or there's no financial resources left. And to me, again, that's a deficiency in the whole process. The proponent, if they want to go ahead with their project, they should have to go ahead. They shouldn't have this ability to keep the community on tender hooks. Needless to say, the terms of reference were approved. As I said, we had a huge document outlining all kinds of concerns and deficiencies in the terms of reference. Basically, the terms of reference were rubber stamped by MOE, and we were told that you raised a whole lot of good points, but don't worry, they will be addressed in the environmental assessment. We, unfortunately, not being experts at the game, we are now. We wouldn't have taken that answer, but we took it as an answer that that's the process, and we have to go along with it. Unfortunately, a lot of those issues were not addressed in the environmental assessment. The proponent said, don't worry, we'll look after them in the environmental compliance approval process. And we didn't really like that, but there's nothing you can do to challenge the minister's approval. And then, unfortunately, after the approval was done, we heard from Rick that the way it works is that we don't really have any right to appeal following an environmental approval by the minister. So we really don't have a chance now to comment and challenge anything in the environmental compliance approval process. So this whole process of pushing things down the road until it's reached a point that the issue is a done deal. There's nothing you can do. The one thing that bothers me with MOE is this business of the environmental assessment being proponent-driven. You go to the open houses, you talk to the proponent, you complain about problems, you bring up concerns. They don't listen to you. They just push on with their process. You talk to the MOE saying that we're not getting anywhere with the proponent. MOE says, no, it's a proponent-driven. Go back to talk to the proponent. And yet the ministry won't come and talk to the community. They will come down. In fact, they did come down and they talked to the proponent. They had a site visit. They talked to him. We invited the ministry to come down and sit down with us, talk to us face-to-face. They said, no, we can't do that. So it's not fair. And I guess before I close, to me, in this whole process, there are two primary stakeholders. One is the proponent who wants the project, who's driven by profit, who's driven by the bottom line, who's driven by stakeholders or stockholders. The other major stakeholder is the community around the proposal. They are driven by the community they live in. They don't want it destroyed. They're concerned about health. They're concerned about safety. They're concerned about cost of living and property values and things like that. Those two stakeholders should have equal weighting in the whole process because they both have the same amount at stake. Maybe even the community has more because they're not going anywhere. That's where they're living. And yet the whole system is geared towards the proponent. The MOE will not listen, as Harry said, they will not listen to the community, even though we may have the credentials and living there. Basically, that local knowledge is much more important than what the consultants who often come from far and wide don't know anything about. Anyway, I'll leave it at that, and we can maybe, if there's questions after, we can get into it. But the whole process is very flawed. It's not fair. It's set up for the proponent, and I think when Rick said that the MOE didn't want to review the Bill of Rights or the Environmental Protection Act, and they said, don't worry, the existing approvals process will take care of it. They approved our environmental assessment, and yet we're on fractured limestone that's leaking, has been leaking for the last 20 years. And so there is something wrong with the approvals process, and it needs to be changed in legislation.